Hello, everybody. We just wait few minutes for all the others to join because there are many people still connecting, and then we will start. Hi. Okay. Hello. I think we can start, even if, of course, many other people are still, some people are still connecting, but yes, we can start at least saying hello to everybody. Hi, and welcome to this webinar. We are very happy because there are many people registered for this webinar, and more than 183 people, I think. So we are quite happy also because there are lawyers from all over the world and different continents, not only people from Europe, but also from Africa and from North and South America and Middle East, and also Asia and Australia, notwithstanding the difference, the time difference. So we are really happy about that, and we hope, of course, that you will enjoy this webinar. I take this opportunity, since there are so many people and not all of them are already involved in IDI, to remind that it is very important for us that all of you join IDI as members by subscribing with the subscription, the annual subscriptions, because this is very important for us for supporting IDI and all our activities, not only this but all the others, and we have many initiatives and activities going on. So, having said that, today we will deal with artificial intelligence and particularly the application to franchise and distribution networks. We will start with an introduction with the first speaker, who is Andrew Balfus. Andrew Balfus is a shareholder of national chair of the franchise distribution and direct sales team at Corliss and Brady LLP in Naples, Florida. He's also an owner of a Neptune Technologies, which is a leading agentic AI company with advanced applications in a variety of industries, including legal, franchise, distribution, supply chain, finance, and healthcare. So Andrew will give us an introduction and will speak about what is AI and how it is changing. So I will share the slides so that Andrew, you can start.
Great.
All
Well, thank you
right.
very much, and good morning or good afternoon, depending on where you're joining us from. Um, as mentioned, I'm Andy Bialfus. I'm very honored to be able to present to you today. My section is going to be a little bit of an overview, and today my goal is to really make AI understandable and practical for you because I know it can be a little bit overwhelming if you're not really used to the AI technologies, and we really need to break them down into various subparts because AI isn't just one technology. There are many different technologies and it continues to advance. And so the first section, I'm going to go over those technologies and really set the stage for the other presenters today who will go into some deeper, more applied topics going forward. So I want to start with what is AI very generally. So AI refers to computer systems that can perform tasks that would normally require human intelligence. This might include learning patterns, interpreting information, adjusting to inputs, making decisions. It could be a variety of things. But the term AI really covers several different categories. And so an understanding of each is essential because each one is for different applications. It presents different opportunities. It has different risks, as we'll see, and different regulatory implications. So let's start with machine learning. Machine learning is the foundation of most modern AI. So instead of writing rules for a program to follow, we feed model data in and it discovers patterns of its own. So machine learning has several different major forms. One is supervised learning. These are models that are trained on labeled examples. For instance, thousands of images that you put in, labeled as tagged as defective or non-defective, can help the model to learn to detect manufacturing errors for faster than human inspectors. Unsupervised learning. This is a model that looks at data without labels and finds the patterns on its own. It's used for customer segmentation, uh, anomaly detection in supply chains, discovering hidden relationships of sales data to make your sales and marketing more effective, things like that. Then there's reinforcement learning. This is a model that learns by trial and error and receives rewards or penalties. This is used in inventory optimization, algorithms, pricing, a variety of different types of go-to-market types of applications. So machine learning is pretty powerful, but it still relies heavily on structured data and well-defined objectives. What we'll see is that there are other forms of AI that aren't so dependent. So let's go to the next one. This is deep learning. Deep learning is a subset of machine learning that uses multi-layered neural networks. So it kind of mimics the structure of a human brain, right? Allowing the system to detect patterns that are too complex for what were traditional algorithms. So deep learning is really good at things like image recognition or sensor data interpretation or autonomous navigation, voice recognition, and translation, which is becoming a big thing in everything from franchise sales to customer onboarding to just general call center type stuff. Complex forecasting across models or supply chains. It's also good for deep learning is also good for that. A good example of this is computer vision in learning, where they can inspect thousands of products per minute with higher accuracy than a trained human. It can see things that we can't. It learns a subtle variation in the shape or the texture or the color or something like that well before there becomes a product recall or something of that nature that you might need to address. So it's a very powerful tool. The next one that we have is generative AI. And now this is where it might start to make sense to those of you that know the world through like a ChatGPT. ChatGPT is a generative AI model, and it creates new content that resembles what a human would produce. The technology behind these is they're called large language models, or you might hear LLM as the acronym on that, or diffusion models in the case of images and video. So generative AI, for those of you that have used it, Can do everything from written communications to writing reports to training manuals, some legal analysis, but you got to be really careful. It is often wrong and it hallucinates, and I'll explain to you why that is a little bit later and how agentic AI will start cleaning that up. Product descriptions, simulated scenarios, so you can put a hypothetical in and it will give you its version of what they think is most likely, right? So this has already changed the way that companies are handling things like customer service, compliance documentation, things of that nature, sometimes even product design. But it also has a lot of risks. So I mentioned before the hallucinations and inaccurate summaries. What the issue with generative AI is that it really searches for an answer and it's dependent on the data in. And a lot of the data sources can be subject to editing or interpretation or things of that nature that aren't based on facts, right? So if that's the case, you're going to have a lot of situations where the model may not actually be pulling accurate information or current information. It might be outdated, but it happens to be the most voluminous type of information out there that it is pulling from. That is why it hallucinates. It struggles and it really wants to find you an answer, even if that answer is incorrect. I'll give you an example of that in just a minute. Once we look at the agentic AI model, I just want to give an overview and I'll explain to you a little bit of a difference of how these things work to give you a real world example. But let's preview agentic first. Okay, so agentic is really what my company does. This is the next major leap. These are systems that don't just answer questions, but they take actions for you. They use agents to operate continuously, and they can work across multiple applications so they all talk to better reason and better find you the right answer or to flag for you something that, in the case of attorneys, that maybe attorneys need to actually look at to interpret the data, or there's some amount of discretion that is involved, or maybe the answer is not to a certain degree of certainty. So let me give you this example. The difference that you might see with an agentic AI model versus a generative AI model is if you were to type in something like, what were the results of the climate summit in Antarctica in 2024? It will give you a very, very specific answer. This is the generative AI. It will give you a very specific answer, including all of the speakers, the things that were discussed, maybe even the dates, things of that nature of the presentation. Here's the problem with that, though. There was no such conference that ever happened, right? It's pulling things like Antarctica because it's often mentioned in global warming and certain discussions about the environment. And when you're looking at these global summits, it will just pull and combine data using common terms that are called, as it tokenizes the search terms that you put in, the prompts that you put in. So it's very specific as to the prompting that you use in order to get the right answer, or at least as close to the right answer as you can. Agentic doesn't do that. You can just ask it a question and it will autonomously figure out the answer for you. So agentic AI can do things like monitor performance across thousands of business units, whether those are franchise operations or otherwise. Pull data from systems, identify issues, escalate problems, generate and send reports. It can update training materials, authorize purchases within your preset limits, schedule maintenance, adjust pricing, run compliance checks. It can do so many different things. It's like having an employee that works around the clock and follows directions. What a dream, right? I know that for the various organizations that I have, I would love to have that, right? And that's what we do have now if you create it. It's also closed source. So, for example, my company can do something where you could have a very specific AI for your organization. The data does not go outside of your organization, so we don't have any issues with things like waiving intellectual property rights or putting things into the public domain or things of that nature. This will be the next real generation of what AI is really understood to be. Now, when we go to the next step beyond, and we're not yet here, but it is coming, is the intersection between the agentic AI and quantum computing. This is still in the very early days, but it can multiply the power of AI models and it will create even new ones. So classic, computers can analyze things one at a time. Quantum computers can analyze millions of possibilities at once. It is unbelievable what this stuff can do or is reported to do. So the shift transforms optimization across pretty much anything that you can see. International shipping, cross-border inventory balancing, energy grid management. It can even hack government codes as far as algorithms and things of that nature that are used for national security. So it's very, very tightly guarded right now. So quantum will allow AI companies to really simulate large scale systems in real time and solve problems that we might not even be able to identify. So the message here is that AI is not one technology, but it's an ecosystem with different capabilities and different limitations, different risk profiles, but also different emerging applications that can be very valuable. So let's turn to how these are used in your industries. And I'm just going to give you a very, very brief overview because I'd like to get into some emerging developments with the regulatory environment before my section wraps. One of the things that you're going to see is that AI is already being deployed in manufacturing, distribution, and franchising in a variety of ways. So, for example, production. There are AI-driven robotics that produce uh, products. They can work on things. They can build things. They can improve precision, detect defects, and things of that nature. So this will increase the uptime and reduce your downtime and repair costs. Very, very powerful. Product development. This can accelerate cycles by simulating certain material performance, identifying weaknesses, generating prototypes, things of that nature. Again, depending on the AI that you're using, you have to be a little bit careful with this though, because you want to protect your intellectual property. And we're going to talk a little bit about that in the sections that follow. Marketing, customer engagement. This is, you can create marketing materials, but you can also use chatbots and things like that to simulate the human experience when you have customer onboarding, answer questions, and things like that. There is emerging regulation in this area. There are chatbot regulations, for example, in the United States. And I do believe that that is going to continue because people are literally fooled into thinking that it is a real human that they're talking to. But it can do great things. For example, in a franchise sales context, it can do things like validate your leads because there are approximately 7 touch points between the first time that you would get a franchisee interested in your system and that time before it becomes a qualified lead where you can actually close a sale, for example, to get a new franchisee on board. That's one of the applications that's been in the market for about a year now, and the bugs are being worked out of that. Inventory and logistics. This is very powerful because it can identify reorder points, balance inventory, and things of that nature. We saw this during COVID, where the JIT inventory was getting way too lean, and so if there was ever a disruption in global supply chain, there wasn't enough product because people didn't have enough product on hand in order to meet the customer need. And so it created a vast amount of problems in the United States as far as product offering, the quality control, things of that nature. So the inventory and logistics is a very, very specific application, but very powerful to offset what we had seen more recently. And now in the age of tariffs and things like that we're seeing, some of the stuff just becomes way too expensive. So you have to plan in advance to keep your costs down as well. And then AI training models can continuously update, evaluate employee understanding, things of that nature, and can be the backbone of your business. So the emerging developments, we already mentioned the agentic is the future as well as the quantum plus AI. So I'm going to skip over that a little bit for the slide here and go right to the regulation. Now, I'm not going to get into a ton of the discussion on regulation because, again, my co-presenters will do quite a bit of that in this speech, and we'll be here to answer questions later. But we have things like the EU AI Act and the updated Product Liability Directive, which represents the first real shifts and the first attempts to regulate AI. They require classification of AI systems, certain transparency, documentation, and human oversight. They will also expand liability where AI influences product safety or decision making, and we'll see that intersection. A lot of the laws apply not only to manufacturers, but also franchisors and distributors who are either responsible for the supply chain or placing products into the market. So these are real risks that we really need to figure out. To wrap in section 4 here, the future direction and risk, the rising risks would include, of course, the greater enforcement that we'll talk about. As this gets to market, it's no different than when we saw, for example, products being sold via the internet and how to tax that, the nexus and the movement and things like that. There are old laws that are being shoehorned into the current technology and they don't quite fit. The regulators don't really understand what AI is, so they're trying their best. But this is going to be a little bit of an evolving process as we have more validation, more oversight, and things of that nature. You'll likely see more litigation because you should expect more lawsuits involving things like product failures caused by AI. You know, crashing autonomous driven vehicles, for instance, right? Things like that. Algorithmic biases, misleading automated decision making, improper updates for causing unsafe condition, and maybe even some antitrust issues if you're using it for pricing. You'll see standardization. The government industry bodies will push for standards to try to explain, to create these audit trails that show what the AI's thought process was, data governance, continuous modeling. And then finally, we're going to have AI plus LLT, right? So as AI connects to devices, sensors, vehicles, operational systems, the risk profile expands. So the behavior of the AI may differ across countries and conditions and in different business environments. So companies will need a holistic set of governance for their entire product distribution lifecycle. So I'll leave you with this before I turn it over to the presenters, the co-presenters. Make sure that you're building an AI governance framework. Strengthen your contracts because you're going to need to know things like data rights, audit rights, things of that nature when you're contracting. Train your employees, right? But not just your employees, train your partners too. Everybody has to have a basic level of how AI works, how to use it, and when to escalate issues to the humans, and to make sure that you're working as a partner with it. Monitor your systems after deployment. These things have to be continuously trained. We train basically and retrain once a week to make sure that the AI is functioning properly. And we prepare for AI-specific incident responses, so have that plan ready to go. So with that, my time is up. I'm going to pass the baton now to, I believe Oliver is going to come in, and I'll be available at the end for questions that exist, or you can contact me offline after the presentation if there are additional questions. So thank you very much.
Thank you very much, Andrew. That was really, really interesting and really useful for people to start, entering into the topic. So now we will have Oliver. Oh, 1 second. Oh, no, sorry. Just, okay. Condivido. Okay, 1 second. Oliver here. Yes. All right. So Oliver Rosenthal, partner of ANXO Management Consulting GmbH, Frankfurt, Germany. Oliver was managing director of creative agency Saatchi and Saatchi and Ogilvy, difficult to pronounce, in Frankfurt, Germany. He joined Google in 2014 and was one of the founders of Creative Works, a creative consultation for Google-led largest advertisers. He was the only member from Germany in Google's Global Creative Steering Committee. He left Google this year and currently works as a consultant for brands. Oliver will speak about the impact of AI in various industries. Okay, the floor is yours, Oliver. Go ahead. Thank you.
Thank you very much. And first of all, to all joining this today, I am very, very sorry that this is only via voice and slides today. I am traveling on an urgent personal matter, and that occurred just recently. And I absolutely did not want to cancel this because I love speaking to you. And please also include me in the Q&A session. Just because my camera needs to be off doesn't mean that I'm not joining in full flavor. So next slide, please. So the reason why I think this cover of The Economist is so spot on, like artificial intelligence is the first form of technology where from the beginning there is already, apart from all the benefits, and Andrew did a great presentation and explained a lot of those benefits to us, but from the very beginning there is also fear. So I'm going to get into the general implications of artificial intelligence on society and business in the next 14 minutes. And like just one example, one of the godfathers of AI, Geoffrey Hinton, who just won a Nobel Prize for his exemplary work. Even Geoffrey Hinton points at the danger of AI doing harm to mankind at approximately up to 20%. And this is not some conspiracy theory person who has crazy theories. This is a man who was awarded the Nobel Prize for his work on artificial intelligence. So lots of benefits, but also a great challenge for humankind. Next slide, please. So I do not want to talk about the recent industrial or the past industrial revolutions with you, but I pointed out these years. And by the way, when you ask Gemini or ChatGPT about the first, second, and third industrial revolution, you will get different kind of answers. But these years are like a bit of common sense. And why is that of interest? By the way, I'm having some noises in the background. If any one of you still has his microphone open, maybe you want to for this session. Thank you. So the one thing that is really interesting here is to see that there are approximately 100 years before the past, between the past industrial revolutions. So quite a large time frame from the beginning of steam engines until the age of the personal computer. Quite large amounts of time passed between these developments. Next slide, please. Before that all happened, so on this graph, you basically see the productivity of mankind for most of history, meaning for the time before the first industrial revolution. I think it's quite self-explanatory, so we can skip to the next slide already. Thank you. So, and this massive growth in terms of productivity is obviously what was the biggest impact on the past industrial revolutions for mankind. We basically produced significantly more with significantly less humans involved in the process. Next slide, please. To be a little bit more specific about how this productivity is now dramatically changing, and not like in 100 years, but right now. If we would be all in a room, I would ask you to raise your hands, or maybe have a QR code where you could vote. But I'm going to also, for the sake of time, I'm going to solve this quiz with you. But first, to understand the question correctly, the question refers to the fact that right now, artificial intelligence reprograms itself without human interaction at a range of approximately 20%. So right now, deep learning of artificial intelligence grows by itself without human intervention by 20%. So the question asks, when will this be 100%? And it is really within 1 year. Source of these estimations is the San Francisco consensus. I really refer this to you. It's a consensus of very smart people in the Silicon Valley. That's why it's called the San Francisco consensus. Eric Schmidt is one of the members of this group, and many of their predictions have to be proven quite accurate. So in 1 year from now, most AI tools will reprogram and grow by themselves without human intervention. So this is like a much bigger impact than recent productivity growth that we have seen with the first, second, and third industrial revolution. Next slide, please. So this is like one of the key takeaways that, basically, if you take away like just one or two things, this would be one of these two things. Because while the term we are now in the fourth industrial revolution, while this term is, to my opinion and to many others, still the best way to explain the impact on society, it is also not, because this is now happening in months and years. That's why I mentioned this one example of programming. There are many more examples. Just look, Andrew talked about generative AI. Just looked at videos that have been produced with, let's say, the first version of VO from Google, like maybe 2 years ago, and compare these videos to recent examples from VO3 and obviously other AI tools. It's a massive speed, unlike any industrial revolution we have seen. Next slide, please. So, and I think this is worth to explore in order to understand what is happening right now. Why can this happen so dramatically? And when we go back, I mean, the first industrial revolutions, the development of steam engines, trains need rails. To reach distant destinations, you need rails. This takes ages to build. In countries like Germany, it still does, by the way. And electricity, which we now take for granted, obviously needs a complex infrastructure, a complex grid. Just look at the United States of America, where this is still sometimes not working properly, causing wildfires and so on. It needs a lot of infrastructure. And obviously, we have been driving with cars for ages, and we need massive investment in roads for that. AI does not need any of this. AI needs the internet, mobile communication, and automation processes. It's all there. So this is why we are running on really high speed here. Next slide, please. This is probably the most important thing I would like to share with you, because also something that maybe we don't really see when we are so fascinated by the development of artificial intelligence. We up to now, we always talked about how to multiply physical capacity, meaning basically how to multiply human capacity, automation, machines, computing, outsourcing, cloud computing. It was always about the multiplication of physical capacity to achieve growth. For the first time in history, and we have never seen anything like that, we are now talking about a multiplication of cognitive capacity, and all the other benefits obviously are still there. And here I don't want this to be like an apocalyptic vision. But when we talk about the multiplication of cognitive capacity, this basically means that in the next years, we will have AGI. If you're not familiar with the term, you should definitely look it up because this is coming. AGI is definitely coming. Artificial General Intelligence, sometimes also referred to super intelligence. There is no clear estimation on when exactly this is going to happen. Estimates range from 5 to 20 years. But let's say, I mean, I can't see you in the room right now, but I would say most of us will probably be still around, I hope, when AGI is happening. And in a nutshell, it means that we will have machines that are smarter than the entire human population. Again, a machine, machines in plural, that are smarter than the intelligence of all people living on this planet combined. Sounds totally crazy, but it is not when people like Eric Schmidt, Geoffrey Hinton, and others from the San Francisco caucus announce this. And this is what's going to happen in the next foreseeable years. Next slide, please. I want to close with this quote. As an ex-Google manager, I much more prefer working with Google products than Microsoft. But obviously, Satya Nadella is a very, very smart person. And what he points out is what many people in the stock markets are fearing right now. If all these wonderful opportunities are there, why don't we see this already in the growth of GPR or privately owned companies? And to give you one insight, I have been working for Google many years. I was in a different field, but still, when you work at Google, you have access, obviously, to all information. And for a few years now, Alphabet, the holding company of Google, is really cost-cutting at a immense scale. But if you see the quarterly results from Alphabet, you would ask yourself, why is cost-cutting such a big topic for a company that has profits of billions each quarter? Because of the massive investments in AI, the investments that are necessary for data centers, for data security, for quantum computing, as Andrew pointed out, are immense. Alphabet, for example, in my home country, Germany, has currently recently announced an investment of $5 billion alone in Germany for data centers. So why is this interesting? All these investments will take time until they show profit. And that is what Satya Nadella here is pointing out, and why some analysts are afraid of a AI bubble burst, which does not mean that AI is not going to succeed, but that the expectations similar to the internet, the infamous internet bubble in the late 90s, might be happening. So these are some general thoughts I wanted to share with you. Really looking forward to the Q&A session. Again, sorry for not being able to show myself right now, but I hope this was insightful for you. And handing over again. Thank you.
Thank you very much, Oliver. It was very interesting, and yes, I will tell to all of you that for both Andrew and Oliver, if you want, any of the participants wants to put a question for them, you can already use the Q&A session. Please use the Q&A, not the chat section, but the Q&A, and then they will answer to the question together with the other speakers at the end at the Q&A session after the discussion panel. So thank you again, Oliver. Thank you, Andrew. And now we will start with the discussion panel. So we will have a discussion panel now examining potential and actual issues that may arise in the use of artificial intelligence by a franchisor company. The discussion will be led by Jenica Solansky. Jenica Solansky is a legal counsel specializing in IT and privacy at Inter IKEA System BV, the franchisor company for IKEA based in Delft, Netherlands. Jenica holds a master's degree in European business law from the Leiden University and a law degree from India. Before joining Intern IKEA, she worked for 6 years at a law firm in Mumbai, gaining extensive experience in digital law, private equity, international law, and other legal domains. So, Jenica, first of all, please be assured that Jenica will not speak on behalf of IKEA, and the cases examined are not situations actually experienced by IKEA, but more general scenarios regarding the use of AI in a franchise system. So those issues and scenarios will be then evaluated by 3 lawyers covering the rules applicable respectively in the European Union, Marco Hiro, in China, Alina Kwok, and in USA, Alan Greenfield. So Marco Hiro is a partner at Scheidermeyer in Frankfurt and he heads the practice group distribution and franchising. He has been a lawyer for over 20 years in the fields of international sales, distribution, and franchising, and he's IDI expert on franchise law in Germany. Alina Kwok is a Paris qualified lawyer and foreign registered lawyer in Hong Kong with nearly 30 years of experience in Franco-Chinese business law. Alina is a co-founder of Asia Alliance with offices in Beijing, Hong Kong, Taipei, and Paris, and advises on cross-border investment compliance and high-stakes disputes resolution across mainland China and Greater China, and also covering distribution matters. She's also a CEDR accredited mediator and serves as country expert for IDI for China. Then we have Alan Greenfield. Alan Greenfield is managing shareholder of Greenberg Towering at the Aspen office, focusing on international and domestic franchising, licensing, and distribution. He advises both established and startup franchise and manufacturing companies. Alan has guided transactions in more than 75 countries, counseling a broad range of clients on expanding their brands internationally through all types of arrangements. In addition, Alan is experienced in mergers and acquisitions and general corporate law. So having said that, please, I will put here the slide, share the slides. Okay, here. No, 1 second. Questa. Okay, again. All right. Yeah, great. So, Jenica, the floor is yours.
Thank you, Sylvia. Hello, everyone. Good morning, good afternoon, and good evening, depending on where you all are right now. Let's jump into various selected legal issues when we are using AI in distribution or franchise system. We will be discussing 3 topics today, and quickly jumping onto the first topic, which is AI and how it is used, how we view it along with intellectual property. As AI tools are becoming more and more embedded in daily operations, whether it's for general marketing or branding, the legal questions around ownership and protection of these outputs are becoming more and more urgent. Franchise businesses are especially vulnerable because they rely on consistency and control across multiple countries. So, if AI generated content isn't clearly protected under IP law, it could expose a franchisor company or a distribution network to brand or legal risk. Hence, it's very important for businesses to get deeper understanding on how AI generated content is protected under IP laws globally. In this regard, I have my first question to this panel. to understand what qualifies as a work that is protected under IP laws when we are talking about content generated by AI. Floor is yours, Alan.
Good morning from Colorado, everyone. I'll take the lead on this topic, and my co-presenters, Alina and Marco, will also discuss from their applicable jurisdictions as well. So in the US, AI is broken out. I'll look at it into 4 phases, ownership of AI. The first is, AI used in the creation of patents and AI-generated patents. Currently, the United States Patent and Trademark Office has taken the position that AI cannot be listed as an inventor on patents. Only humans can be inventors. So therefore, if you don't have human involvement in the process, you wouldn't be able to obtain a patent registration. However, if a human uses AI assisted inventions, that may still be patented. And there was a case on that a few years ago, and that's currently where things stand with respect to patents. With respect to trademarks and AI used in the creation of trademarks, currently the rules are similar to normal trademark law. If AI is used to help create a logo or a brand, that is allowed, and that is, you can obtain a trademark from that. And in fact, a lot of marketing departments in companies are already doing that. AI is also being used by the US Trademark Office to review and help assess trademark applications and to detect potential infringements. So on the government enforcement side, they're already using AI to help in that respect. There are concerns as one of the examples I think that I heard Andy mention regarding the fake climate conference. There are concerns about using AI, generated branding and to create trademarks. But currently at the moment, right, as long as they're not infringing on someone else's trademark, it can be used and it can be registered. The next is copyrights. And there has been guidance provided on this a couple of years ago. And at the moment, any works that are created entirely by AI is not copyrightable, similar to patents, because copyright requires human authorship. As long as there is substantial human input and AI is used as a tool to assist, that is, can obtain protection. However, the US Copyright Office will evaluate that application on a case-by-case basis and determine whether there is substantial human input. And as I mentioned, a couple of years ago in 2023, the US Copyright Office, they provided this guidance that said content that is mixed with human authorship elements, only the human created portions of that work are actually qualify for copyright protection. So, keep that in mind as you develop, as companies develop materials. And then lastly, in the US, there's the trade secret protections. And that one, AI models and algorithms are of all these large companies we're talking about, OpenAI, Google, and others, and Microsoft, they are protected as trade secrets. Their software and their coding. And so that does apply to AI at the moment. Let me ask you, Marco, how is it in the EU in this respect?
Well, in the EU, we don't have a law or an act defining work, copyrights or similar. We have since last year the EU Artificial Intelligence Act, the AI Act. However, it regulates different things like transparency, accountability, but not authorship. So in the EU, we have to look at the national level. Looking at my jurisdiction in Germany, we have a copyright law, and a copyright arises only from a human author and an intellectual creation by a human only. So that excludes purely autonomous machine output, as it lacks protection. However, what we're looking here now is a hybrid of human AI output eventually, and that may qualify if the human input part determines the creative result. So what is the creative result? Well, the idea itself, then prompting it into the software, the design, then selecting the AI proposals and editing them in the end. So it's a case-by-case view. However, it is possible that a hybrid work could be copyright protected.
And Alina, is it any different? How is it in China compared to our jurisdictions?
No, I would say that in China is the same. So I will not repeat. Machines cannot be authors of work. So it's the same kind of regime. What I'd like to maybe to detail here is some recent decisions made in China regarding the authorship for AI. To just give you an idea of the criteria that are used in China. In a decision from the Shenzhen court issued in 2020, the Tencent used AI called a Dream Writer to edit and generate a news article. And the court found that although the process was automated, the fact that there was a human intervention with a creative input, such as selecting templates, data sources, and an editorial oversight, shows that the article was protected under copyright law. And there is also a very recent decision from the Shanghai court issued in November of this year, which is the first AI prompt copyright judgment, mentioning that so it was an art company that generated paintings using prompts, sets of prompts. And the court found that these prompts were mere list of artistic styles and visual elements without structure or a personal creative imprint. And the court decided that these prompts were not copyrightable works. So what is very important is that there should be a personalized intellectual input to qualify as a copyrightable work.
Thank you. Thank you, Alina, Alan, and Marco. So what I'm hearing is that it depends upon the jurisdiction and human intervention to determine the authorship. Which brings me to my next question about how do you think we can use licensing agreements with such AI tool companies to affect ownership? Alan, how do you think this works in the US?
Yeah, I mean, that's extremely important because, permitting training of an AI tool using a company's data, they could be using confidential information. As we all know, as the attorneys attending today's webinar, right, we have confidential client content, and using our client content to help train these systems would violate our confidential requirements, right, with our clients. And therefore we can't. And so law firms develop their own tools, but it's similar, for our franchise companies and other companies, right? They have oftentimes confidentiality requirements with their customers and their partner data. And if you allow these AI companies to train their tools using this confidential information, you could be in violation of those agreements. I guess in addition, I would say that, when a company engages one of these AI providers, it's important to negotiate these licensing agreements to take the position that they should not be training their models using this company data. And talking with our IP specialists and more, actually our digital technologies specialists, they are negotiating those types of contracts and taking that position regularly. What they're actually seeing, which I found very interesting, is that you have AI vendors and their standard contracts that are provided to companies. These AI vendors are trying to claim in these contracts ownership of the model output. And so that needs to be negotiated. But some AI vendors are even trying to take the position that they own model input. And for those of y'all who don't know, model input is are the prompts that are used to generate the output. And so there are vendors out there in their licensing, in their agreements that will take ownership to those prompts. And so it's important to negotiate, as a company, to maintain the ownership of both the model input and output. And so, those who may not be practicing in this area or regularly reviewing these documents, or maybe it's the marketing departments that are using, these tools and obtain these license agreements. It's important for us as the council, both in-house and external counsel, to take a look at these licensing agreements to be able to negotiate these topics on ownership of the input and output. And Marco, I'll turn it. Well, let's actually reverse. Let's go to Alina. How is it in China on this issue?
Same thing. Anything could be in China. Anything could be mentioned in the contract as regards the ownership of the output of the input. So the contract rules the obligations and the ownership. What I'd like to maybe to point out is that in China, for practitioners and for drafting contracts, it's a very textualist approach. Courts, they will rely on what's written in the contract, even if the parties have different intentions. So it is very important in this regard to draft very explicit clause in for the protection of the works and the ownership.
Marco, how about in the EU?
Yeah, just adding to what the two of you just said. Since only humans can be authored, ownership of AI-generated material depends also in most jurisdictions in the EU on the contractual terms. So my recommendation is that users like franchisors, distribution systems, or persons should ensure that the license agreement expressly grants exclusive, transferable, sub-licensable rights to the output and specifically permits the network-wide exploitation within a franchise system. For instance, if it features a part of the franchisor's know-how, for instance. And what I want to point out is that it should include warranties and indemnities against IP claims, and it should confirm ideally lawful use of training data. The reason why I emphasize this is because right in time for this IDI seminar on November 11, actually, a first court in Europe ruled on the use of copyright protected works by AI systems in a professional context. GEMA, that's the German Collecting Society representing the interests of around about 100,000 music creators in Germany, filed a lawsuit against OpenAI. The starting point of the proceedings was the use of song lyrics by 9 well-known German authors. It included Rolf Zukowski's unforgivable, obnoxious children's song In the Christmas Bakery, which terrorized generations of parents, including myself and others. GEMA argued that the lyrics had been memorized in the GPT model parameters and could be reproduced almost verbatim, amounting to an unauthorized reproduction under several sections of the German Copyright Act. The regional court of Munich is of the opinion that both the training of AI and the output of the AI are subject to licensing under copyright law, provided that works worthy of protection are not only analyzed, which is allowed under the copyright law, but also defined in the AI models in such a way that they are memorized, that's the key term, in the original and reproduced almost in the original. The judgment is not yet legally binding. However, there are very good arguments in favor of AI providers having to conclude licensing agreements with the collecting societies, at least where they exist, such as GEMA in the future, if their model is trained with protected content and memorization cannot be ruled out. Going back to the uses of AI solutions in companies, I recommend to ensure that the systems used have been legally trained and that licenses for copyright relevant content are available, because this is just the first landmark ruling. However, there are many to come. I only know about pending cases in my country. For sure, there are comparable cases in all your jurisdictions at the moment. In that case, OpenAI has announced an appeal. The judgment is not yet final, as I said. It may be even reviewed not only by the higher regional court in Munich, but also be referred to the Court of Justice of the European Union. In practice, for software providers, we come a little bit later on to if the franchisor provides this kind of software, it may require layered mitigation measures, internal guidelines restricting the output, filters to block reproductions and similar. But we get to that in the second block.
That's interesting, Marco, because that's ahead of where we are here in the US, having an actual decision on this issue. We have dozens of pending class actions in the US on that issue, and brought similarly by our Authors Guild here in the US. There are several pending against OpenAI, Microsoft, Meta, Google, and those so far have had mixed results. But again, it's the same, sounds like a similar claim as to your case in Germany, right? Alleging copyright infringement of the author's works used to train their AI models. We did have one settlement before, right? There was a result with Anthropic here in the US. Anthropic agreed to pay the Authors Guild, actually it was probably about 500 authors, 500,000 authors, sorry, $1.5 billion as part of this settlement. And, in reading about, the defenses, they're trying the developers, right, are taking the position that this is falls under the fair use doctrine and being able to use these books and these materials to train their AI systems. However, we don't have a ruling on that yet, and we see Anthropic agreed to settle for 1.5 billion. So we'll see where that, similar, the other cases end up, I guess, in the next year or so. Sorry, Jenica, but yeah, that's very interesting.
No. Yeah, it is an interesting topic, and I think that it gives an important insight also to a scenario that comes to mind now, is about how what would happen when a franchisor develops a promotional campaign, let's say, which features a catchy jingle lyrics, and the lyrics are written by the marketing team of the company. So, and the melody or the music is generated by using a paid AI music tool, and then which is licensed for commercial use and tailored to the brand of the company. The jingle is in English and the lyrics are in English, and then it's used across the global marketing channels. When distributed to franchisees, a franchisee which is a non-English speaking country, let's say, for example, localizes the campaign and uses a different AI translation tool to convert it into the local language. And this translated version, which is then launched, is discovered to, let's say, infringe a local popular song. It raises kind of different questions about, is the original jingle protected? And what about the translation? And how do we view liability between the franchisor and franchisee in such case of infringement? Maybe you could shed some light on this scenario as well. Alan?
Yeah, I think here the important aspect of it is, right, the lyrics were written by the franchisor's marketing team. So you would argue, right, there's substantial human input in developing those lyrics. So I would say in the US, they'd be protected human work. The melody may be protected, I believe. It really, number one, as Marco and I we were all talking about, as long as that AI tool, right, had the right to use that melody, because I assume, it took it from somewhere. And again, where it gets a little complicated, right, is there's substantial human input for the melody portion of that for copyright protection. So, that would be looked at on a case-by-case basis. The translation, that could be argued it's a derivative work, right? That is protected. But it really, again, depends on the extent of the music adaptation, as it talks about that tool by the AI tool. It doesn't seem like there's substantial input, human input for the translation, right? Because it says they used a separate AI translation tool to convert it. So, it would, if it doesn't qualify as a derivative work, I don't believe it would, or I think it would be challenging for it to obtain its own protections of the translated version. And I guess the liability allocation between the franchisor and franchisee, really depends on the extent of the involvement by the franchisor, as we talked about, what licenses those tools obtained from the music industry and others. It does talk about, it is licensed for commercial use. So I'm assuming for our purposes that they had, that the AI companies had proper licenses to develop the music used in this. But, at least on the original English version, I would say that a typical franchise agreement would make a franchisee responsible for, any actions or any claims that arise in operating their business. So, when you look at liability, the starting point under a franchise agreement is usually this franchisee would be liable to indemnify the franchisor if the franchisor is brought into the claim. But, as we'll talk about later, and as Marco pointed out, it really depends on, the extent of the franchisor's involvement as to whether it could have liability as well. Those are kind of the issues I'm seeing from this scenario. Alina, what are your thoughts?
Same in China. The original single would be protected by copyright. The translation is a derivative work, so it needs to get the authorization from the franchisor to translate it into the locally. And as for liability in China, everything depends on the level of control and authorization. If the franchisee had acted independently or used the AI beyond the franchisor's approval, then franchisee would bear primary liability. If the franchisor approved or supervised the adaptation, then both could be jointly liable. So it really depends on the level of control and authorization. So I believe it's the same than in the US.
And Marco?
Yes, funny enough, we stretch here around the global, but come to very similar results with respect to this. I'll make it very short. The lyrics under German law are protected as human work. The AI melody, as I said before, is protected, but only if the human input was decisive in creation. Regarding translation adaptation, the same as in the US, as I just learned, it would probably qualify as a derivative work. And with respect to the infringement, of course, it depends on the contractual allocation. Let's assume in a typical or standard situation, the franchisee bears the risk for unapproved localization under German law. However, under German law, there is still joint liability possible. And as we know that as franchisors, a typical standard franchise agreement might feature release or indemnification clauses to protect the franchisor from being jointly or several liable for acts of the franchisee. Of course, if the franchisor approved the work and they were negligent, at least both, they are joint liable again. We cannot find out in that case scenario who actually, or what was the role of the AI software provider in the end. However, looking into the new case law I just mentioned and the tendencies of litigation in the US, there is a good chance that the AI software provider might be liable in case it infringed during training of the software copyrights of third parties.
Thank you so much for that, because that gives a good, how do you say, a transition into our next segment, which is exactly about how we allocate liability between franchisor, franchisee, and also in this case, AI companies, which get in the mix of this, which becomes particularly difficult to identify, especially in global franchisor distribution networks where liability is taken in or viewed in different scenarios globally. I think the first question that arises is how can businesses ensure that franchisees or their partners use AI tools safely? Alina, would you want to shed some light as per your jurisdiction?
Yes. As you said, Janika, the integration of AI tools into commercial networks creates a network, a web of actors, data providers, model developers, platform operators, distributors, and end users, each of them contributing to an output that might be partially autonomous. So the liability becomes shared and layered. In China, as I said previously, everything depends on how much control the parties have on the process, and which will determine the liability of each actor. So there are three layers of safeguards in China. The first is regulatory compliance. In China, the authorities have adopted a very structured regulatory framework for AI, which imposes obligation on providers and users. So both the franchisor and the franchisee may bear liability from issues resulting from AI use, such as generating misleading or illegal content, infringing third parties' rights, personal data that is processed without proper consent, and also not comply with China's algorithmic transparency. So in the businesses, they must implement some mandatory compliance procedures, which are approved tool list. So partners may only use AI tools that are authorized by the franchisor and compliant with Chinese law, data handling standards, prompt engineering policies, content validation. And for this mandatory human review is very important in this regard. And also the training is also important. Franchisees must regularly complete training on safe AI practices, data protection, etc., etc. The second layer is traceability, which is very important, is paramount in operational governance. This requires to issue audit logs of AI-generated decisions. This also involves a clear attribution of human responsibility and also escalation procedures when AI outputs appear abnormal or discriminatory. So the maintenance of audit trails is very important so that the network can demonstrate that human oversight existed at all times. And finally, the third layer is contractual arrangements. This is the most effective tools, which is to draft a very detailed contracts with obligations of the parties. In this regards, the Chinese regulations are also very detailed about how to conclude agreements and taking into consideration several clauses. So they are listed and enumerated in the regulation. One specific Chinese regulation of generative AI services for companies, establish some usage standard, clearly defined responsibilities, indemnity clause, of course, strengthen the management of the data and also the security management, such as conducting legality review of the data input, and also establish a supervision mechanism, like regularly check the use of AI tools, including the quality of the generated content, and the implementation of data security measures. So, and finally, taking also corrective measures is very important. This has to be put down in the contract when the franchisees or the partners, they violate compliance requirements, and these corrective measures should include warning, suspension of cooperation, or termination of cooperation. So it's in China, everything in the contract can be very detailed in order to have a safe use of AI. So how about US and Germany?
Well, I see it similar, two perspectives: the contractual governance on one hand, and the act governance within the EU. We have to map roles. Under German contractual law, there is a freedom which allows franchisors and franchisees to allocate risks by warranties, indemnities, representations, and detailed processes. Specifically in Germany and eventually in Austria, we have these rules on general terms and conditions, which set the borders a little bit narrower with respect to what can be put in a franchise agreement than in other jurisdictions eventually, but we are free to do that. And we mentioned some examples on the slide before. Secondly, we have this AI Act in Europe now, and it speaks to that. It maps, we have to map the roles with respect to the provider, deployer of the AI, and it imposes duties on deployers. We have to maintain logs, for instance, on the AI Act. We have to have human oversight under the AI Act. We have to provide transparency for user interaction. We have, of course, to be GDPR compliant in the processes. Also, there are operational obligations on AI providers. Apart from transparency, they have to introduce a risk management. They have to document that, of course. And as I said, there are human oversight requirements for certain systems and general purpose AI. So there is, under the EU AI Act umbrella, there is a whole compliance body required and introduced, which has to be followed.
In the US, we'll keep it short here. It's the same as your jurisdictions, as we're finding out from the other concepts. The only thing I'll add is that, being a franchise question here, a franchisor ought to make sure in its franchise agreement with the franchisees that, the compliance, there is a proper compliance with laws provision, right? The compliance with laws If you want to make tweaks to an agreement, right, you can say, at least in the US documents, that they comply with all applicable, including without limitation state AI laws, because they keep developing. I wouldn't be too specific there because we have new ones being enacted. And then the franchisor, as we've talked about, should negotiate the proper indemnities with its service providers and vendors. Otherwise, it's the same.
Yeah. Thank you, Alan, Alina, and Marco. I think you already shed quite some light on how contractual governance can affect liability and how these should be modified. But I just wanted to check if you want to add anything briefly, specifically on indemnity clauses and how these should be modified. Yeah, Alina?
So in China, the indemnity clause, of course, is unforeseeable, but it is not absolute. What I mean is that a party cannot use this indemnity clause to escape mandatory legal obligations. And this is the first thing. The second thing is that Chinese courts, they might revise the indemnity clause if, for example, the indemnity is disproportionate. So or if the clause is too general. For example, a hold harmless for all losses clause for formulation will be probably narrowed by the judges, and the liquidated damages, if they are excessively high, could also be adjusted by courts. So what is important for the indemnity clause is to be precise and proportionate. The clause has to identify what is the conduct to be, which conduct is covered, what types of losses are indemnified, who bears the responsibility for which part of the AI systems, and also the procedures for justice and cooperation.
Anything to add, Alan and Marco, on this? Or is it the same?
I'll just one sentence here. In the US, right, it's similar in the respect of not that the courts will rewrite the indemnity provision, but it's the vicarious liability. So despite the language in your indemnity provision, if the franchisor is involved in that action, right, you have to deal with vicarious liability claims and risks.
Indeed.
I just want to add one new legislation coming up. We have the Product Liability Directive imposing duties on our member states within the EU to update the local and national product liability laws. Germany has done so, and as given by the directive, Germany includes software now from end of 2026 on in the product liability. So software will be handled or seen liability-wise like a product. And as probably in all jurisdictions, product liability is mandatory. So whatever the franchisor regulates in the indemnity clauses and tries to limit it, at least for civil matters with respect to product liability, as a supplier of the AI software, the franchisors will be fully liable, as they are liable for any product they produced or brought into the market.
Thank you. So that also brings an interesting scenario of what happens when a franchisor develops an AI-powered chatbot, let's say, for example, using a third-party LLM to assist customer in finding products and product information. And this chatbot, let's say, is trained using company-owned data and internet data as well, and then distributed to the franchisees, which locally adapt this in their regional markets. And in one of the regional markets, a customer asks the chatbot about certain things, which then certain product, which then the information provided by the chatbot contradicts consumer laws locally. It's interesting to understand as to who is ultimately responsible for such a chatbot output, and whether there are any guardrails that should or pre-approved content for franchisees when using this tool, and how about holding third-party AI providers accountable Could you shed some light on that aspect, Alina?
Yes, so in China, there is a dual liability system. The franchisor, he bears the duty of supervision, and he has to ensure that the system's training, the parameters, the base content comply with law and do not produce misleading statements. The franchisee, on his side, as the local deployer, has to bear operational responsibility to verify that the local adaptation aligns with the consumer protection rules. So if the chatbox error was caused by a local modification, the franchisee would bear primary liability. But if the franchisor failed to provide legal guardrails, pre-approved content or monitoring mechanism, then the liability could be shared.
Yeah. Is there anything to add, Marco or Alan?
I would add here that, you know, in this scenario, the franchisor is the one developing this, working with a third party. So, you know, we would look at one, hopefully, as we were talking about earlier, the franchisor negotiated the proper protections with the developer, that third party company. However, in the US, right, and this was mentioned earlier in the presentation, we have these state chat box laws, right? There's one in California, one in Utah. So if this were rolled out system-wide and this system failed to comply with those laws, right, I would say, number one, despite your indemnity in your franchise agreement, this is a franchisor developed tool. It was rolled out to the system. There's going to be vicarious liability with the franchisor, and the franchisor is ultimately going to be responsible in its failure to comply if it failed to comply with these laws. However, right, if this responsibility was allocated to the third-party vendor, right, that under that agreement, then we would, you know, they would seek that indemnity from that vendor. That's how, you know, we would address this issue in the US. Marco?
Important to negotiate good agreements.
I just want to add a couple of thoughts similar to what we just heard. But this case became really practical for me earlier this year when a young startup restaurant franchise brand came to me. And when I ran through my preliminary checklist, what they have already and what not, I asked for the manual. And they told me, the shareholders, they don't have a manual and they do not intend to draft one or hand one out because they have a chatbot. And the franchisees can ask everything they want to that chatbot. So it was the first time that I spoke to a chatbot in order to find out if it gives the right answers under legal perspectives here. Just to add what you guys said, of course, with respect to the third-party provider liability, many vendors, of course, disclaim liability for user outputs over here and limit their indemnity. Under current EU law, the third-party provider may still have to comply with regulatory obligations under the AI Act, which I mentioned earlier, technical documentation, transparency, and so on. But civil liability is still governed by national laws. That allows probably to limit liability. Again, I remember at least the mandatory product liability coming up, but that might not be applicable in any case. I also advise, we come to that in a second anyway, that antitrust regulations are mandatory, and it is difficult to, limit liability for that.
Thank you. Thank you. Yeah, I think, Marco, the last part, I think about what you said about how limiting liability under antitrust law is also a good segment, good getaway into our next segment, which is about AI and antitrust law. But keeping in mind, I think the time we'll briefly touch upon this. It's also interesting how AI in franchise business is changing, and it is defining how data is used, how markets approach. It is different now when we have AI in the mix, and especially when we talk about pricing, data sharing, market coordination, these with the use of AI tool could unintentionally lead to anti-competitive behavior. Here, could you shed some light to the extent of to what extent can use of shared AI tools between the franchisor and franchisee, such as pricing algorithms, constitute a collusion or a price fixing, even where it's unintentional, and how such AI-driven systems influence market behaviors under antitrust laws, and what are the justifications? So maybe Marco, would you want to go first and take the lead on this one?
On this topic, I can speak on the EU level because we have the EU treaty, and Article 101 prohibits agreements or concerted practices that restrict competition. Of course, every member state has its national mandatory legislation, but it implements the EU competition principles domestically, not more, not less. EU competition law treats resale price maintenance specifically as we call it hardcore restriction in vertical relationships, which franchisor distribution systems are, at least in one aspect from franchisor to franchisee. We have the vertical block exemption regulation and the vertical guidelines, and they confirm the hardcore restriction. The increasing use of shared or centrally issued AI pricing tools raises two distinct antitrust concerns. One, vertical concern, franchisor to franchisee. If a franchisor requires franchisees to use an AI price setting tool that fixes minimum or fixed resale prices, that is very likely RPM or resale price maintenance, and therefore unlawful, unless an individual exemption under Article 101.3 can be proved, which is really difficult, I guess. Even price recommendations can be problematic depending on the tool's design and enforcement features, but that has been the case also before AI already, and is case law in Germany, for instance. Secondly, horizontal concerns with respect to concerted practice risk, inter-competitor algorithmic coordination. Let's look at the franchisees on a horizontal level and or the franchisor operating own restaurants, retail outlets, or businesses on the same level with the franchisees. Where multiple independent undertakings use the same pricing algorithm, or where an AI system learns competitors' prices and franchisees are competitors on a horizontal level through market data, factual pattern, may amount to a concerted practice or a tacit collusion, at least under Article 101 EU treaty. And that should be treated serious, definitely. Our national authority, the Bundeskartellamt, but also EU authorities have expressly warned that algorithm or algorithmic pricing can facilitate collusion. Investigations and enforcement scrutiny are increasing, probably worldwide even. It's an interesting new topic, but technically, of course, very difficult, because the legal standard is very fact intense, and also difficult still to understand unless you have people like our first introductory speaker on your side. Unintentional violations through automatic pricing, I make it short, still actionable if the algorithmic's design or operation eliminates independent decision-making. It remains a hardcore restriction, also under the block exemption regulation. And the third aspect, is there any justification? I cannot think of one, so that is up to us to invent one in the future. We're having such a case and defending companies in this situation. The efficiencies under Article 101.3 of the EU treaty possible only if the benefits outweigh restrictions and consumer gain a fair share I don't see that yet, but that's something we'll learn in the future.
Thank you, Marco. Very quickly, Alina and Alan, anything to add on this topic of antitrust laws?
So quickly, in China, the AI-enabled price discrimination has been a real concern. If I remember well, according to a survey, something like 80% of the Chinese population thinks they have been the victims of this AI price discrimination. So the Chinese regulations are very protective of consumers in this regard. And the second thing I'd like to add also is that the intent, to address the second question, the intent is not necessary. What matters is the effect on the market competition. So if a company use algorithms to deal with a price, then it can be a concerted practice.
And in the U.S. perspective, it's similar, but I would say two things. One, the tool still has to allow the franchisees to be able to choose their own pricing, right? In the U.S., you can oftentimes set maximum prices, but not minimum prices. So we have to see what the tool does in effect. But from a practical standpoint, I'd say the risk really is, what's the effect of this, of this system on consumers? If it has an effect of lowering prices for consumers, I would say the risk is low, right? Because they're going to look at this tool used to drive down prices. But if it's opposite and this tool had an effect of increasing prices for consumers, I think the risk is high. And I think there's a risk of claims at our federal level, right? Under the FTC, state attorney generals under the state level, or even consumer class actions. And so it's important, to look everything holistically.
Yes, thank you. Thank you. Maybe if we have 5 more minutes, Sylvia, then we can quickly get some insights while we have Alan, Alina, and Marco on how they, if they have any general insights, knowledge, or any tips to share with us on how do we, deal with everything related to AI coming our way in from a holistic scenario. Maybe you want to go first, Marco?
Did you jump to the practical strategies?
Just the practical synergies, because we only have 5 minutes left.
We jump over the case scenario, right?
Yeah, because I think most of what you said does cover what we've already discussed in that.
Well, I hope the discussion panel shows that the integration of AI into a distribution of franchise system raises a variety of legal questions, and many of them are still unresolved, but there are judgments coming. Practical strategies and solutions. Well, establish an AI policy as a franchisor, definitely. Role mapping, as I said, inventory under the AI Act, that's something you have to do in the EU, definitely. Insert sooner or later, depending on the complexity of your franchisor client or your system, explicit AI clauses, usage limits, approval rights, indemnities, audits, vendor warranties, and so on. While until last year, I tended to add sentences at several clauses within in my existing standard franchise templates, I gave that up. Meanwhile, I switched completely. I have a separate new paragraph in a standard template with the things I believe, and it's developing on a monthly basis almost, have to be included in a franchise agreement. And then I can pick, depending on the complexity of the system, the paragraphs which are relevant and delete those which are not yet relevant. Third, documentation. Maintain prompt and output logs. I see one of the Q&As goes on to how to prove that. Well, the act forces you to document anything, but however, in any litigation, in litigious situations, the prompt and output logs will play an essential role with respect to IP infringements and other things. Yeah, maintain the model versions and so on, as, let's say, keep compliance evidence. Human oversight, I mentioned it a couple of times. Fourth is important. However smart your software is, make it mandatory to review for legal compliance, consumer protection, depending on where it is used, and the last topic, pricing outputs, at least. Fifth, very regular standard compliance issues, implement training and monitoring, periodic AI compliance audits, integrate competition law and data protection modules. Yeah? And last but not least, get an insurance for all these kind of things in case a hiccup pushes through and you have to pay on whatever level to whoever. These are my recommendations.
So in addition to Marco's recommendations, I would also, it's important to prioritize privacy and the security risks of customer information. I think that can lead to increased risk if not prioritized and handled properly. Also, while not mandatory, you got to consider individual consents, right? Again, these are practical steps to try to reduce risk. If you have consumers and your suppliers who you're using the information to help train these tools consent to your doing so, right? You've addressed one of the major risk points as a company using AI. So I would add those two as well.
Thank you. Alina, any?
Well, my two colleagues said everything, so I have not many things to say. Just one specificity about China is that it is a very policy-driven country. And Chinese authority, they do sanction companies that do not apply and that are not compliant with all the regulations. So I would add to have a proactive regulatory legal watch on, because there are regulation laws that are issued almost every week on this. And also China, they have maybe more than in your countries. They are very procedural. So the filing the AI tools is mandatory. So watch everything that needs to be done in China to be compliant and to abide by China rules.
Thank you. I think these are some great tips and strategies for all the participants here to take this back to their company and to make sure that they govern the topic of AI more closely as well. Over to you, Sylvia, for I think the question.
Great. So really, thank you very much. It has been a very interactive and interesting discussion, and you didn't just address the issues from a practical perspective, but also provided solutions and advice and from all the perspectives. So I'm really happy and thank you very much. Having said that, we can open the discussion. Unfortunately, we cannot we cannot give access to the microphones to all the people, but there are already questions in the Q&A session. I don't know if you can see them in order to see who will address them. So, Silvia, can you please read the chat? Okay. The slides in the screen. Sorry, Silvia.
I think there are two of them, Sylvia. The one's from Hans regarding the EU directive, and then the last one.
Yeah, perfect. So, Marco, would you answer to the first one on Hans?
With respect to the EU directive, the copyright protection under the directive applies to databases which, by reason of their selection of arrangement or their contents, is still the author's own intellectual creation. So, as I mentioned at the beginning of this panel, the human creativity is key. And if AI is used as a tool, if a human uses AI as a tool and makes creative choices in the selection or arrangement of the database's content, the human author could potentially claim copyright protection for that structure.
Great. So then there is another question from Horst Becker. Have you seen it, or shall I read it?
Yeah, I read it. It's regarding the authorship so basically it's saying if someone uses AI to generate music or text or something and then lies about it and says they did it on their own, you're right. You know, how would one be able to demonstrate that AI was or wasn't used? From what I've seen, the AI companies are working on that, right? They are using, for example, if it's text, they're using coding to show currently that it was generated by ChatGPT or others. And you know, and then I've seen ways to get around that and whatnot that they're posting online. So I expect this to continue to evolve. With respect to music, I haven't tested it myself, but I haven't seen anything immediately that identifies that music or rhythm is generated or not by AI. But I suspect it will be coming, that there will be a way that the AI tool you are using will somehow, especially if they're claiming ownership of the output, they will somehow identify that they are the owner of that, or they are the creator of that. So that's what I've seen.
Alan, I can address that too. You're exactly right. You can tell. There's even programs with universities with plagiarized works and things like that, or derived works from the generative stuff that's been around for a long time. All of the you can very easily plug this stuff into AI to determine if it was created by AI now. And so that's not really going to be an issue. The actual coding and stuff like that is probably beyond what we have questions for in this seminar. But there are ways that you can do it where you can figure out if it was a natural work or it was derivative. What the challenge becomes is if it was wholly created by the AI versus if it was created and then tweaked, into something else where it kind of becomes something different, right? Because there was a famous lawsuit with Ed Sheeran where the way that he had won his case was to take a guitar into the courtroom and play the same 3 chords and basically be able to show that there are about 100 songs that are based on the 3-chord algorithm or progression that would be there, right? So that's where it becomes a little bit different. If it's wholly created by the AI, you can figure that out with AI. If it's derivative still further from a little bit of a base and then some customization, that's where the confusion is. I'm not sure what we're going to be able to do with that going forward.
Any other answer to this question from other perspectives, or there are other two questions? Otherwise, if Alina and Marco, you don't want to add something to this.
I actually have a question, if I can, to Oliver, because your presentation, Oliver, was really, really frightening. So if the machine can learn better than all of us and can do better than all of us, what remains to the humanity? I have kids, so when you say that the machine could totally replace humans within 1 year or more, what do we do?
Yes, thank you, Alina, for that question. So the replacement within 1 year, that was pointed specifically at the further development, the possibility of AI technology to teach itself. So that does not imply that humans are at that point already a kind of danger. It's difficult to answer, and I'm obviously not the wise prophet who can say something to that. But from my background, which was always creative solutions for advertisers for Google, which is a technology company. The answer to your question might be a generational topic. So I am when I listen to music, when I watch a TV drama or a feature film or go into the theater, I am very much interested in the artist. I would not be intrigued at all to watch a Netflix series created by AI. That would not interest me. I am afraid future generations that grow up with AI might not have that distinction. So there is actually a fear in the cultural scene that what has been the dominant key indicator of art, that it is being produced by humans, that might not be the differentiator anymore. So, but I think in that area, arts and the creation of content, that is something that could be a dominant topic for humans for many years. Machines do not dream. If they dream, they hallucinate, and that is not a very positive thing. But I think it's going to become the main question for the next years. When do we reach a point where AI really could do more harm than benefit?
Well, this next presentation, Alina, is going to be done entirely by AI and replace all of us. So, you know, I think that can start our fear, because we just have to prompt it properly and we're done.
But I also wanted to just add that it's so right, Oliver, what you said, because there is also concerns being raised. And just this morning, it was in the news that Google also made a statement around this, that no companies are going to be safe if the AI bubble bursts. So really going to see like a crash if that were to happen. So concerning for sure.
Any optimistic view?
Well, I think so. I think that there's going to be ways that you can integrate with the AI, with, you know, there's Neuralink and things like that, where we're already seeing the integration between, you know, computer generated assistants, where it raises the human intelligence levels and things like that. There are AI ethics committees. That's why quantum computing is so closely guarded right now. There are very few people that have access to it, and the governments are kind of getting involved. The problem is that the governments are not nearly at the same technological advancement level as a lot of the AI companies, so they don't really understand what they're regulating. So, you know, the government officials are a little bit behind the curve, and because these developers cost a ton of money, trust me, I know, they cost a ton of money. Meta just offered 8 individuals $100 million each over 5 years to make the switch, and these developers weren't even the elite ones in their field, right? So very expensive. So governments are having a hard time keeping up with the private sector as far as the evolutions. But there's got to be some sort of integration between the companies and the governments to have some ethics or some limits on where this goes. But the real advancement is going to be the quantum computing, and there's very few people that have access to that right now. Google has it, you know, a couple of others. So I think we'll figure it out. It's just to be determined right now.
I would add one thing, just since everyone on this webinar is interested in AI, right? I just happened to watch it last night. It was playing in the background. There is a very interesting 60 minutes episode on Anthropic's use of AI in their offices. And I encourage you all to watch it, because what they're currently just testing internally in their offices in, I think it was San Francisco, 3 offices, San Francisco, New York, and one other. It's basically taught AI to run its own business. It's a vending machine business. And then they even appointed, it was losing money in some cases. So they created a secondary AI to serve as the CEO of the AI, and the two of them communicate behind the scenes to set prices and everything. It was very, very interesting. It is running its own business, and you all should watch this if you're interested in this technology, because it was fascinating.
All right. There are other two questions. One is, what is the protection regime, database rights, trade secrets for synthetic training data under EU and US law?
So we answered the first question in the beginning, I believe, but it's the right now it's, you know, the traditional patent law, trademark law, right, copyright law, trade secrets. So those are the protection regimes currently governing the use of AI. So I don't know if anyone else has anything different to add.
Yeah, as we said at the beginning, purely AI generated databases are at the moment at least unlikely to qualify for copyright protection. Any company wanting to protect its synthetic database may heavily rely on contractual clauses to manage access and the use. When data protection, I think, was mentioned as well. Well, that GDPR protection would only apply if that database was trained with personal data. Otherwise, it would not apply. I also told you the AI Act regulates only quality, governance, and transparency issues for training data, especially for high-risk data. So trade secrets in the EU are, of course, without any problem protected, and that would probably also apply to a trade secret generated in a synthetic database. The information cannot be generally known. It must be of commercial use, and the user has taken reasonable steps to protect it, which leads to trade secret compliance systems.
Good. Also to you, Marco, any indications which companies or practices the EU Commission is currently investigating, especially whether this has an AI angle?
Yeah, as mentioned during the panel, I see two tendencies all over Europe. One is the question if AI software, multi-billion and trillion companies can use all these copyrights for free or not. Of course, they're saying, of course, we can use it for free because we have to train our databases. But as we learned last week in Munich, it's not about training. There is commercial use and content. Memorization will be the key term probably over the next month and years with respect to that. And the other one is the antitrust situation, which we also highlighted earlier.
And in the US on this issue, I think there was some investigation actions by FTC's or state's attorney general on, if you look it up on pricing, the software used for static or pricing when it comes to airline tickets. I think there was a lot of pushback and complaints because depending on how you search airline tickets or whatnot, timing availability, they were using some AI in these tools. I recall seeing that, but I'm not, intimately familiar with it.
Okay.
Can I ask a question here, especially because Marco spoke about antitrust, and that's also one of the questions in the chat, and also one of the questions I had in my scenario, which talks when we talk about pricing or market behavior decisions, and who is responsible when we talk about franchisor, franchisees, and AI responsibility. Could you shed some light on that? Like, could I think there was a question? Yeah.
Well, the franchisor and franchisee may be jointly liable under Article 101 EU Treaty. If they use algorithmic software, for instance, the vendor of the software may be liable as well if he knowingly facilitated that antitrust behavior. Enforcement and sanctions may target the franchisor as the, let's say, the organizer and the supplier of the AI algorithmic pricing mechanisms. Franchisees could be treated as participants in the anti-competitive arrangement, let's say, and may face joint liability under Article 101 EU treaty and national law, by the way. So that bears ultimately high financial exposure, which of course depends on the facts and the amounts in charge and the contractual indemnities.
And Alan, from the U.S. perspective, do you want to chime in, or you want me to do it on the who's responsible at the franchisor, franchisor, vendor with the mitigation under the U.S. antitrust laws?
You can go.
Yeah, basically, I think it's going to depend on a couple of factors. If the AI is an approved vendor or a technology or mandated, we have to have some sort of an agreement, right, with the vertical price fixing. That's under a rule of reason analysis in most states in the U.S., right? So when we're looking at certain things, it's going to really depend on the factual situation. So if the AI is mandated or if it's pushed down, we're seeing a little bit of this with the elimination of the penny right now at a kind of different level, right? Where in the United States, they're eliminating pennies, so they're not sure what to do with rounding either down or up in order to meet the requirements of a pure cash transaction, which is required in various jurisdictions. It's kind of the same thing. You can suggest certain policies, things like that, but you can't mandate them. So the franchisors would be well advised to have certain contractual prohibitions of using AI to control data or pricing decisions or something like that. If the franchisees want to use it as a data input, they may be able to glean certain information and things like that, but to set the pricing, they really need to impose some discretion. And then as far as the vendor, all of them could be sued, conceptually in a very vicarious liability standpoint. I do not think it would be a defense or a mitigation to say the AI did it, right? Because you're still responsible for the technologies that you use, and then the ultimate implementation of the pricing policies within the marketplace, which is the real violations. It'll be a little bit different between horizontal and vertical, but I do not think that AI did it is going to be a defense in any way. So I think you really need those AI policies that Marco and others had referred to make sure that you know what's used. You need to see if it's a required vendor, and they need to know how to use it. And that's what goes back to the training and watching the evolution of this, because we're really kind of shoehorning or bootstrapping in laws that were not created to address these situations that need to evolve over time. And so we're going to need to just kind of be very cautious of the use at the early stages as the law develops. I don't know if you want to supplement that, Alan, but that would be where I think this is going at the U.S. level.
Nothing to add.
Okay. Yeah, I think you've addressed the last question of Luciana of sharing, no? Or, I mean, in terms of, so she's in terms of international practice, what would be the best approach? The franchisor supervision of AI customization by franchisees, even if this generates liability but preserves the brand, or not?
I mean, I would treat this like any other use of, whether it's marketing materials, whether it's website design, similar, anything else that franchisees are doing that could harm the brand and the franchisor. So, you have to balance the amount of supervision and the extent of the hands-on that a franchisor has with its franchisees. But, if you're aware of a franchisee using AI in terms of, brand, I don't know that I would get necessarily in the weeds, but I would definitely have an understanding of the contract with the vendor, ask the right questions. Has this been protected? At the end of the day, it's similar to all those other areas of risk that I identified, right? You can have an agreement that indemnifies you for that franchisee's use. But if it turns out the franchisee in this market, and let's just say it's an important market, and maybe it's a master franchisee that has, or even a multi-unit developer that has, control of that country, And it turns out they're using AI, and they're either, let's just say, antitrust risk, right? It's driving up prices, or let's say it's using customer data or chat box in a way that doesn't comply with the law. It harms the brand. And so we need to appropriately balance that risk. So I believe there should be a level of supervision or understanding of a franchisee's use and obtaining consent. And as part of that consent, this is just my opinion, as part of that consent, the franchisor should have an understanding of, what protections are in place in respect of use of that AI.
And to supplement that, the indemnity is only as good as the person that can pay it. The damages in this context are going to be extreme. You'd be very well advised to mandate additional insured requirements, that the franchisee get insurance to indemnify the franchisor or the top level, because a lot of times they're not going to be able to pay it, and somebody is going to look back at the vicarious liability upstream to the franchisor. So the insurances, I think, are going to be very important, because this is kind of driving in the dark, right? You don't know where you're going, but if you got the headlights and you're able to kind of steer, great. But this is going to evolve, right, over time, and so there's going to be liability that can't be projected at this point. So make sure that those insurances are there, and that those assurances name the franchisor as an additional insured, because they could be quite expensive as well. So mitigate that risk by pushing that expense down to the franchisee level as well. And make sure you're getting annual updates to ensure that those certificates are renewed annually, because they may get it once and let the policies lapse later. You don't want that, right? You want to make sure that you've got some sort of ongoing compliance protocol as well, to make sure that you get those certificates of additional insured languages.
Alina, Marco, would you like to add something, or?
Alina first.
Maybe point out one specificity in China is that China is a closed system. So using, for example, a foreign AI tool is subject to filing procedures. So in the principle, foreign AI tools are not forbidden in China, but in practice, due to this filing obligation, there are not many foreign AI tools that are used in China. So if the franchisor, if the franchisee, has to adapt to the local context, it might use local tools. So my suggestion as regards China is that first, to comply with all the obligation standards, filing, etc. This is really important, because today companies are getting sanctioned very seriously. And second, in the contract, specify that since China has a specific treatment with the specific tools, the liabilities should really be well defined.
Marco?
Listening to the speakers and at Luciana's question, the answer is obvious. How could a franchisor not supervise AI in a system? And as Alan said, it has to be treated as any other issue as well. First of all, legal-wise, it mitigates the franchisor's exposure under contract or product liability-like regimes in the future. Secondly, brand reputation, because it helps to demonstrate compliance with the AI Act and all the other relevant laws and views of the customers in the future. And practically, it prevents inconsistent consumer communications, price fixing, regulatory breaches in local markets, and so on.
Great. Good. So I think there are no more questions, and we are really in time, 5 minutes in advance. So if you don't have anything more, between you, further questions or comments to make, I would say thank you very much to all the speakers, and it was really a great webinar, and very lively and interesting. So thank you very much. And yes, I think I will just take a few minutes to speak about the next conference in order to inform everybody about our next event. The next conference will be in Lisbon next year in June, so the 5th and 6th of June 2026. We will deal in the main session, the Friday session, we will deal with managing termination and post-termination in agency distribution and franchise agreement. In particular, there will be a morning session dealing with termination issues, how to manage termination, considering both the moment of termination, but also the moments preceding, the periods preceding termination, like the notice period, which is always critical for a critical moment, and also, you know, we will see if it is possible, for example, to impose restrictions in that period, which were not provided in, provided in the contract, but different from the general rules applicable to the rest of the contractual relationship. We will see also from an in-house counsel perspective what are the critical issues regarding the transition from a distributor, a former distributor, to a new distributor in case of termination. What are the main risks and issues arising when the distributor, the terminated distributor, is in financial difficulties? We will see where in some jurisdictions there are limitations imposed to the unilateral termination, for even by notice, and so we will discuss about that, and also about strategies particularly referred to franchise agreements aimed at keeping control over the franchise locations after the termination of the franchise agreement. So these are the topics, almost all the topics that will be discussed in the morning, and then we will deal in the afternoon with post-termination issues, particularly, you know, all the typical, I mean, always covering broad all agency, distribution, and franchise agreements in different sections. We will, of course, the typical issues related to post-termination are the managing of the stock, the selling of period, warranty performance, and again, here we will have the perspective of a company first to address all the issues, and then we will develop through discussion panels of lawyers in different jurisdictions, specific topics. For example, the post-termination non-compete clause in agency agreement, particularly considering the case where the principal at the end of the contract would like to waive the agent's obligation, non-compete obligation, provided in the contract. Is it possible or not? Under which circumstances? And up to which moment it will be possible or not? Then another issues typically arising in franchise agreements in this phase of post-contractual relationship regards the personal guarantees. So when the agent is a company, often we see personal guarantees issued by the individual, which is the main shareholder of the company, not only for payments, but also assuming personally the certain obligations, for example, non-compete obligation, post-term non-compete obligation. So we will discuss on how and to what extent these clauses are actually effectively enforceable in some jurisdictions or not. And then we will discuss about the typical case of termination of a master franchise agreement and of course, the desire of the franchisor to keep control of, get control over the network of sub-franchisees in case of termination of the master franchise agreement. Is it always possible as provided by contractual provisions or no? What can be the problems in that? So just to say that the main session on Friday will deal with all these aspects related to termination, but as always, from a practical perspective, I mean, addressing the real issues that come across in this moment of the contractual relationship. Then the workshops on Saturday. We will have, as for those maybe who do not know, we always have 3 workshops on Saturday morning, parallel workshops on different topics. And the topics next year will be, the first will be avoiding litigation in distribution and franchise agreements, with a special reference to mediation, the use of mediation. Use of mediation also in certain cases also as a tool for keeping the relationship alive. So while we will also deal, of course, with the most typical case of use of mediation after termination, in order to avoid litigation, but also with, as I said, with another perspective. So the first workshop will be concentrated on this topic. The second workshop will deal with manage the situation we are seeing in the last years, not only custom tariffs, increase of raw material prices of raw materials, and so managing the impact of unforeseen situations on cross-border distribution and franchise networks. So, of course, the impact of these difficult situations, how they impact the relationship, the contractual relationship between the parties in distribution networks, how to allocate the liabilities, how possible force majeure or hardship clauses can play a role in this scenario, and this type of issues. And the third workshop will be on distribution in different industries, how sector dynamics shape legal strategy in distribution and franchising. So we will deal with specific industries. I mean, we will address the typical problems arising in specific industries, related to specific industries. Firstly, fashion and luxury goods, then food and beverage distribution, health products, medical device and cosmetics, and restaurants and hospitality franchising. So trying to focus on what are the typical and actual critical aspects characterizing each different sector. Always, as I said, as we do, so taking the many different perspectives, the perspective, first of all, the angle of the company, which is the living actually these issues. I mean, I'm speaking for the whole topics of the conference, and then creating panels of discussion of involving lawyers of different jurisdiction in order to, you know, have a discussion like you have seen today from you know different jurisdictions, perspective of different jurisdictions, and an exchange of view. And in the end, often, as we have seen today, there are similarities, even if we depart from very different perspectives and rules, but then we always see that there are similarities in the approach, in the strategies, of course, in dealing with these topics. So with this, yes, I think we have finished earlier than we expected, but that's better because we are always very busy and running for something else. But really, I wanted once again to thanks our speakers because, yeah, you have been very, very good speakers. All the sessions were really interesting and good in these topics, which sometimes risk to be held only on a superficial level. But in this time, I think you really managed to really go into the real problems, and as I said, providing also solutions and guidelines. And so thank you very much, and thanks to all the attendants and the participants. So we are really, really happy that now we still have 71 people after this long seminar. So thank you very much to all of you, and of course to my Francesca and Carlotta, who supported with all the help and everything, as always, in order to have these results, good results for all of you. So thank you very much. Bye-bye. Have a good evening.
Thank
Bye.
you.
Thank you.
Thank you.